Hello, ladies and gentlemen. My name is Paku Khan, and I'm with Ketan & Co., one of India's oldest and largest law firms. I'm an executive director of our competition and antitrust team, which is also one of the oldest and largest in the country. And on behalf of Ketan & Co. and our co-hosts, which include the internationally renowned law firm of Simpson Thacher and the IVCA, or the India Private Equity and Venture Capital Association, which is the apex association representing the PE and VC community in India, we want to wish you a very, very warm welcome to our webinar today. And we have both a truly international panel and a truly international audience spanning the entire globe. Now, first of all and foremost, we all hope that you're staying safe and healthy during these trying times. And this webinar, we believe, is probably one of the first of its kind in India, with the focus on the PE and VC community on the behavioral aspects of competition law rather than merger control. And we're delighted with the frankly massive interest for this webinar at a very large audience, and we think a webinar like this is long overdue. Now, we're going to cover a very large amount of information in a very short amount of time, with about 50 minutes to discuss with you the key points about competition law and how it affects the PE and VC community. And after that, we'll take questions from our audience for about 10 or 15 minutes. So we'll try to take about 1 full hour, more or less, and we may run over a couple of minutes, so please oblige us. Just a couple of operational ground rules for us. If you're hearing us and seeing us, that means everything is fine. We can't hear you or see you. One way that you can interact with us on this is through the questions box, and we would very much welcome your questions. Please enter them at any time on your control panel. On the GoToWebinar control panel, just type the question in at any time, hit enter, and we'll try to get to those questions today if possible, and worst case, we'll try to send you an email. I just also want to mention one thing. This is a live broadcast today. We are going to be recording this broadcast and rebroadcasting it for the United States tomorrow. And we'll send you the slides, a link to the recording of the webinar and a few additional materials probably sometime early next week, so please be on the lookout for that. Now, let me introduce my panelists. If we can move on to the next slide, please. Great. So we have them on video and also up on your screen. And if we take the video, let's go back, please. Okay, very quickly, if we take the panelists from left to right, we have John Terzakin, who's up on, I believe, on the left-hand side of your video. John is from the internationally renowned law firm Simpson Thacher, which has offices throughout the United States, Asia, and Europe, as well as Brazil and Tokyo. John is the global co-chair of the antitrust and trade regulation practice for Simpson Thacher and represents international and domestic clients in government enforcement and private litigation of cartels and other alleged antitrust violations. Prior to joining Simpson Thacher, John was one of the leads in the United States Department of Justice Antitrust Division, and he held the very senior position of Director of Criminal Enforcement, where he oversaw the division's criminal enforcement nationwide. I've known John for a number of years, and he's an absolutely superb lawyer as well as an absolutely superb speaker. And John, we're delighted that you could join us and that Simpson Thacher could co-host with us. Moving on the slide to the right of John is Anisha Chand, who's my partner. Anisha is based in Mumbai, and I've worked with her for a number of years. She's advised clients in some absolutely watershed cases in India, in the cement cartel case, the tire cartel case, and the auto parts, both in cartel and abuse of dominance cases. We're particularly proud of Anisha because she was just recognized under the Global Competition Review's 40 Under 40 this year of outstanding young competition partners. And so, Anisha, thank you also for joining us. Then next to Anisha on the slide is Jolly Abraham, and Jolly is the director of legal for True North, a private equity company and financial investment company. And she set up and heads the legal function within True North, advising on legal and regulatory aspects of True North's investments and exits. Prior to joining True North, Jolly was a partner at a leading Indian law firm where her practice spanned cross-border private equity, M&A, and financing transactions, commercial contracts, and advice on corporate law, securities, foreign exchange, and contract law. She secured the first rank at the University of Mumbai in her LLB course on the way to earning her Bachelor of Laws degree. She also holds a Master of Arts in Personnel Management and Industrial Relations from the Tata Institute of Social Sciences and a Bachelor of Arts degree in Economics and Statistics from St. Xavier's College in Mumbai. And I believe that one of the reasons we're delighted to have Jolly, as well as our keynote speaker who I'll address, is to give industry perspective. John and Anisha will give it from the legal side, but Jolly and then our final panelist is Rajat Tandon, who is the president of the India Private Equity and Venture Capital Association, the IVCA. He is focused on planning and developing and implementing the IVCA's regulatory and advocacy functions while identifying solutions for members to maximize their experience in the private equity and venture capital industry. Previously, Rajat was part of the leadership team at NASSCOM, which is the Apex India IT and IT-enabled services BPO body. And in his role as vice president, he headed NASSCOM's 10,000 Startups initiative, providing crucial support to technology startups in India. So in the interest of time, and just very quickly, myself, I've been involved in antitrust for around 30 years, having worked in the United States, Europe, and India, and I'm actually speaking to you from the Bay Area today. So let's move to the next slide, please. And just to give you a very quick outline of what we're planning to do, I'm going to take you through a 3-minute spin of the Indian competition law. Rajat, as our distinguished speaker, as the president of the IVCA, will give a keynote address for a brief time on what he feels are some of the key competition law issues in the private equity and venture capital space. And then we'll turn the program over in items 3, 4, and 5 to John, Jolly, and Anisha, who will give us the substantive views on how the competition laws affect PE and VC firms and how you can try to avoid some of the pitfalls. So that will be 3, 4, and 5. And at the very end, like I said, we'll take about 10 minutes to have Q&A. So please use that question box to send us questions. Next slide, please. All right, so let's quickly go through an overview of competition law. And there's really only 3 sections. And the first one is on anti-competitive agreements, which is in Section 3 of the Indian Competition Act 2002 as amended. And there's really 2 parts to it. One is horizontal agreements and the other is vertical. And so we have 2 boxes, one on your left, horizontal. Now this is going to be what we primarily think of as cartels. And this is where competitors basically align themselves, if you can see my hands, one by one, and essentially, because of that agreement, create some kind of potential negative effect on competition. On the right hand of your screen, we have vertical agreements, which is Section 3.4, which is where you have 2 separate entities in a vertical chain, where one has some indicator of market power, and potentially that affects competition. Let's move on, and we're not going to go into great detail at this point because John, Anisha, and Jolly are going to cover that, but we just wanted to lay out some of the key sections there. Let's move to the next slide, please. Now, Section 4 of the Competition Act deals with abuse of a dominant position, and it's exactly what it says it is. There's two elements to a case. One is that the entity has to have a dominant position, which is actually quite rare in practice. So that's an issue of market definition, as well as industry and sectoral facts that you apply. And then there has to be an abuse of that dominant position. And here we've listed out from Section 4 of the Competition Act the 6 different types of abuses that there can be. Now we're moving on to the next slide. Merger control is something that probably many of you are familiar with, and we're not going to spend much time on that except to say that this is, if we can move to the next slide, please. The merger control is basically the inorganic acquisition of potential market power. So we've had vertical agreements where the agreement creates market power. We have abuse of dominance where a single entity or a group itself might have a dominant position. And then we have the acquisition of that inorganically. We have the thresholds here. We'll send you our guide after the webinar is over on merger control. If we move on to the next slide. I just want to bring a couple of points to your attention about merger control, and that is if you have to file, and those are based on the thresholds on the previous screen, you file with the CCI, and that immunizes the transaction itself. However, it doesn't immunize anything that has happened with the companies that you may be acquiring, and that's exactly what we're going to be talking about in the remainder of our program. If you don't have to file, it means the transaction potentially itself could be attacked under Section 3.4, and you still also potentially have to look out after the issues that your portfolio companies may have engaged in, and that's what we're going to be talking about. So let me now turn it over to Rajat to give some keynote points about the importance of competition law compliance in the private equity and venture capital space.
Welcome everyone on the webinar, and thank you Ketan and Paku for the opportunity to IVCA to partner on this particular session. As we all know, that the Indian PE/VC investments today stand at about $45 billion. Competition is also building up, and this is an important topic. Certainly competition in the marketplace is good for consumers as well as business. But when business compete, consumers certainly get the best possible price, quality, quantity of the goods and services. With that said, competition is also regulated by law enforcement's provisions and framework, as Paku just discussed. The competition law introduces a level playing field for all market players that help market to be competitive and provides the market with a set of rules of the game, which is very important. And that protects the competition process itself rather than the competitors in the market space. Now, with the growing importance in the last decade, we've seen towards an increased level of scrutiny by competition regulators worldwide. Competition regulators have been very strong enforcement powers, and the news headlines make it impossible to ignore. With the increase in interest of the regulators in this new age sector like technology, they're also developing nuanced and better assessment tools to curb anti-competitive behavior. And with new debates and expanding tools, the reach of the law is wider, and it is even so important to be compliant with these laws for all of us. So we have long been seeing competition law only with respect to the merger control side, and I'm not being able to give much importance to the other substantive provisions like anti-competitive agreements and abuse of dominant positions. As the debate on ill effects of common ownership grows, develops rapidly, there is a sense that regulators will up their ante and assessment of the cases which involve financial investors. So we have to be on guard, and actually, we have seen strong growth in investments in the tech sector, well supported by numerous incubation programs focused on technology growth and development. Many investors have multiple investments in the same sector, And this trend is increasing, getting seen in the tech sector specifically. However, on the flip side, cases of competition law violation in the tech sector have also increased globally and in India as well. And as I mentioned, the market grows to about 45 billion, and the growth has been pretty phenomenal. So we will have to be careful about these fronts. So with the increase in private investments, competition law risks are also increasing. Contractual rights have started to be closely examined by regulators as indicators of influence or control. Now, global trends have suggested that regulators may look to fix liabilities on financial sponsors on occasions of violating by portfolio companies. So the degree of liability and the penalty may vary. But as we saw in the previous section, competition regulators do have highly intrusive and strong penal powers. So as investors, we sometimes do not go in details of competitive law compliance in our diligence exercises. But the recent trends are a warning light, and it is time to understand the nuance of this law and to better align our investment decisions with antitrust laws. Many deals have been deferred during the lockdown COVID period, and now as the economy gears up to revive, these deals along with new ones will foray into the market. The pandemic brought about an extraordinary combination of quality assets going cheap and investors being cash rich. The fund that can find the right investment opportunities in this difficult time will not only emerge stronger, but also generate significant returns in the coming years. As a closing statement, I think the topic of this webinar is very timely and utmost crucial to be discussed. With that, I think I'd like to hand it back to Paku to take on the session. Thank you.
Rajat, thanks very much for those comments, and we genuinely appreciate your industry perspective. And speaking of industry perspective, I think now it's time to move on to the heart of our programs in sections 3, 4, and 5. And Jolly, we're delighted to have you with your role as legal director for True North, and want to get your insights on something called unilateral and coordinated effects, which I think is a complicated way of referring to sections 3 and sections 4 of the Competition Act. So Jolly, over to you.
Sure. Thanks, Paku. Glad to be here, and I'm looking forward to this discussion. Can we move to the next slide, please? Most of us who are listening to this discussion would be familiar with the definition of control and what control entails. Control is typically seen as the right to appoint a majority of directors or to control the management or policy decisions of a company. Now, this right to control can be by way of can be acquired by way of the your shareholding in the company, or it could be by way of contractual rights that you have. So you may have less than the threshold in India for appointment of directors is a majority, so 50% plus 1. So as long as you have that, if you are at that shareholding threshold of 50% plus 1, you will have the ability to appoint a majority of directors. But even if you are at below that threshold, by virtue of contractual rights that you have, you could have the right to control. Now, here I'm talking about the traditional definition of control that we would typically look at in corporate law. However, in the context of competition law, the right to appoint a majority of directors is not the only factor that determines whether or not you have control. The concept of control is much wider in competition law. And it's important to examine that and how you acquire control in a company, even though you may have a minority investment in the context of competition law. So clearly, if you have greater than 50% holding in the company, you have you have control for all purposes. Of course, it's a higher degree of control if you are at about 75% because you meet even the special resolution thresholds. So, and of course, anybody who is as low as 10% has certain rights under company law in terms of how they can influence the affairs of the company. That said, so we're putting private equity investments in this context. A private equity investor may take a controlling stake, in which case, if it is in excess of 50%, clearly there is they will have rights under law and don't necessarily have to rely on contract to be able to establish that control. If they are at under 50%, but have contractual rights of the kind that are described on the slide, the typical rights are representation on the governing body, which would be the board committees, the fact that a board meeting or a committee meeting cannot be held without your presence to form quorum. These are where you have to be represented, and so therefore you have an ability to influence the decision. So you may not be a majority, but you have an ability to influence the decision by virtue of these rights that you have under your shareholders agreement that you have. Another type of right that you will have, which could translate into control or influence, are the veto rights. Now, your veto rights can be your typical minority protection rights, such as matters in relation to amendment of constitutional documents that affect your rights, significant mergers and acquisitions, and those kind of transactions which are material to determining what your stake is in the company, what the value of your investment. Those are matters that are typically looked at as minority protection rights or veto rights that an investor may have. In addition, you may have rights like in relation to operational matters with regard to appointment of key managerial personnel, with regard to business plans, and so on and so forth. So when you have veto rights crossing over into these operational matters, they tend to be seen as matters where you are exercising influence on the affairs of the company, and therefore I believe there is jurisprudence under which those rights have been interpreted as joint control of a company, though they may not be viewed as control traditionally. And of course, finally, there is the right to be represented in the form to be present at board meetings, though you are not a director, in the form of an observer, and you could have information rights. Now, while this by itself does not translate into influence in relation to the company at hand, because you are only having access to information here, where this raises a competition law question is how you use this information in connection with your other investments. So if you have investments in competing businesses, then you will be in competing businesses, and you have information because of your presence of your right of an observer right, or because of the information rights that you have from one business, you can use that information to coordinate activity in relation to the other competing business that you are also invested in. So that's where the information rights and right to appoint an observer can raise some questions in relation to from a Section 3 and 4 point of view under the Competition Act. These are just a broad outline of the ways in which you can have influence, which is translated as control for the purposes of the Competition Act, and therefore could raise issues under Section 3 and 4. Over to you, Paku.
Thanks so much, Jolly, for teeing that up for us. And now let me turn it over to Anisha, who's going to walk us through the concept of unilateral and coordinated effects, and also the curious case of common ownership, which I think is something that is an emerging issue in competition law. Go ahead, Anisha.
Thank you, Paku, Rajat, and Jolly, for introducing and setting the context to the webinar so well. I think it's made my job much simpler. But before I delve into explaining the antitrust concerns here, I would mention that much of the debate regarding the likelihood of competitive harm from common ownership really revolves around two main issues. First issue is whether the institutional investors with shareholding across an industry have an incentive to dampen competition. And second is the ability of these institutional investors to influence the decision of the company's board and management, whether directly or through underlying incentives. Now, to be able to answer these questions, we need to appreciate that institutional investors, it could be banks, private wealth funds, pension funds, etc., they have an interest in the performance of the industry at large, rather than the performance of individual firms and competition between the firms. In fact, there are studies which sort of indicate that there have been certain detrimental effects of common ownership in concentrated markets like airlines, retail banking, pharmaceuticals, etc. For instance, there was a study in US which actually examined the airline sector and observed that 3 major airline operators had 5 common financial investors. And what was done was an analysis to see the trend in the airfare before the common ownership and post the beginning of common ownership. And what it indicated and revealed is that ticket prices actually surged very gradually in the range of 3 to 11%. And the study actually attributed that to be stemming from these common ownership. But that aside, generally speaking, the influence from common ownership is, from an antitrust perspective, can be categorized into 2 main buckets. One is unilateral effects, and the second is just the opposite, that is coordinated effects. Now, what do I mean by unilateral effects? Unilateral effects are actions which typically refers to price increases or decline in quality or variety or innovation that firms can profitably implement without really needing to coordinate with competitors. Now, in a perfectly competitive market, a firm would not be able to profitably, being the operative word here, profitably deviate from such market equilibrium, since enough consumers would switch to the firm's competitors to make this deviation unprofitable. Now, let me give you an example. If company A were contemplating, let's say, a unilateral price increase, it may have been constrained by the fact that it will lose customers to company B with whom it is competing. And the marginal gain that company A makes from the price increase would not really make up for the loss of this customer. However, in a situation where company A also has a minority interest in company B, would company A still hesitate in implementing the unilateral price increase? The answer is probably not. Now, why is that so? With a minority share in company A, some of the customers who leave company A could begin purchasing from company B, and therefore a portion of the profits from those sales could flow to company A. Thus, really the loss of profits from the loss of customers pursuant to the price increase could be partially mitigated by minority ownership of B, and thereby contributing to like a upward pricing pressure. Now, of course, there could be a range of factors like the size of interest in company B, the amount of price increase, concentration in the industry that will determine whether the price increase would in fact be profitable as a result of the minority shareholding. But what's important to note here is that communication or agreement between the 2 companies, being company A and company B, is not required for this outcome. I am conscious that this example that I gave you is an example of cross ownership, but the underlying theoretical incentive would equally apply to common ownership by institutional investors. In summary, common shareholding is suspected to lead to sort of short-term or long-term price increases due to lessened incentive to compete between commonly owned firms. Now let's go to the next theory, which is the theory of coordinated effects. And this is really an alternate way in which common ownership could affect competition if it incentivizes institutional investors to facilitate coordination amongst portfolio firms. Now, the basis of concern here is that linkages at the shareholder level could facilitate understandings between firms to not compete aggressively, or could increase the incentive to not deviate from coordinated outcomes. Now, for example, if major competitors in an oligopoly compete less aggressively, prices may tend to go above competitive levels, and the firms may effectively be exercising market power. Such coordinated effects may arise from concentration of shareholding in a sector, which may make coordination of conduct between competitors easier in the hands of common investors. Now, again, what is important here is that unlike unilateral conduct, these anti-competitive effects based on coordination need not depend on partial control or active influence of common investors, but it can also be based on communication mechanisms. Now, for instance, an investor who holds shares in multiple firms in an industry could act as a cartel ringmaster, passing information between the 2 companies and monitoring compliance. In this respect, we can consider the role of investor in coordination to be similar to that of a trade association in a cartel. Now, with this sort of theory, I'll take you through an interesting case which has happened in India involving two radio taxi operators, where the Competition Commission of India has voiced similar concerns. Next slide, please. This is the case of Meru Travels, and it was filed against Uber and Ola. All people living in India would be familiar with these two radio operators. The CCI in this case looked into common ownership issues and its effect on competition in the market, and it had very interesting observations. What it observed was factually that there were just two major app-based taxi aggregators in India, namely Uber and Ola, which had four common investors. Now, one of the investors had a sizable stake with rights to appoint directors in both the companies. And even though this investor arguably had a minority stake, it still had the ability to exercise material influence over both the companies. The CCI noted that overlapping ownership interests in competing entities may imply a reduction in the firm's incentive to compete when contrasted with a situation in which the competing firms are controlled by a separate set of investors and may thus give rise to antitrust risks. Indeed, this case was closed for lack of evidence that competition between Uber and Ola was compromised in any form, but the Commission did emphasize that common ownership may soften competition in the market and may increase the risk of exchange of sensitive information that may facilitate price collusion, or it could restrain capacity or volumes, etc. The Commission also went on to say that an institutional investor, despite passive or non-controlling investments, may affect the competitive dynamics of the market. While closing the case, it actually cautioned the parties in this case that it would monitor their market behavior and see whether adequate safeguards are put in place to ensure that competition is not compromised by common investments. On that note, I will now segue into the concept of sponsor liability, which I will briefly introduce. And then John is going to take over and really look at the real and tangible risks for institutional investors. So much like the EU competition laws in India, a parent company may be held liable, may be held jointly or severally liable for antitrust violations committed by its subsidiary, where the parent company exercises decisive influence over the subsidiary. That's right. Regardless of the separation of the legal personality, a parent company is liable for the actions of the subsidiary because they're considered to be a single economic unit. And secondly, what's important is that the parent should not just have the ability, but also in fact should have exercised this decisive influence. And this doctrine of single economic entity raises many concerns relating to influence and control, where an investor especially becomes a single largest shareholder. And this is something that John is going to throw more light upon. But generally under the Indian competition law, liability statutorily is not restricted to the legal person, the legal person being the company which is found in breach, but it also extends to natural persons, which includes directors and key managerial persons of the company. And the relevant provision under the Competition Act in India makes every person who at the time of contravention was in charge and responsible to the company for the conduct of the relevant business is liable to be prosecuted and penalized. Has this provision been used? Answer is yes. The provision is routinely used by the Commission, and individuals who are relevant to the business, which is the subject matter of investigation, they are routinely prosecuted and liabilities routinely affixed on such individuals, including CEOs and managing directors of the companies. Fines that are imposed as could vary between 1 to 10%, because 10% is the maximum cap of the 3-year average of their income tax returns. Just as an example, there was a case of Bengal Chemists and Druggist Association where a total of 78 high-ranking members and office bearers of the association were found guilty, and fine was imposed along with the fine that was imposed on the association for cartel conduct. From the perspective of investors, Overlapping portfolio may present an opportunity to have common directors in competing companies, and such overlapping directorship can carry a high risk. For instance, if it is shown or where it is shown that the directors had a key role in orchestrating anti-competitive conduct, the investor director could also be liable. With that, let me pass on the baton to John, who will illuminate us further on the quickly evolving concept of sponsor liability and the risk for investors.
Thank you, Nisha, and thanks to Kaitan and everyone for inviting me to participate in this. I think where I would start, given where I'm located, is to talk a little bit about the fact that the competition laws themselves are global. I think one thing to remember as you consider the risks here is any investments in a portfolio company, you're not just considering the risks of the location where the investment lies, but where they are selling or performing the services in that particular entity. And that is to say, when you think about antitrust law and the jurisdiction of either the private plaintiffs who want to pursue these entities for an antitrust violation or the authorities that want to pursue them for a potential violation, that jurisdiction in most areas is effects-based, meaning where you sell the product or where you perform the service. So that is, if you have an entity that happens to be located in India, but they sell products into the United States, for example, private plaintiffs there or the regulator there would have as much right to pursue a potential antitrust violation as would the Indian Competition Commission. So I think thinking about antitrust as a global matter is important, particularly when we're talking about this area. And frankly, the just growing interdependence around the world of a lot of these companies and the shrinking of a lot of these particular industries. So maybe just taking the concepts that Jolly spoke about and also Anisha in terms of these theories that the antitrust authorities are becoming more wedded to surrounding PE investments and sponsors generally, and pointing a little bit to the evidence of risk. And that is some growing sense that both private plaintiffs and antitrust enforcers are becoming increasingly aggressive in trying to find ways to essentially pierce the veil of what would be the portfolio company's liability and getting to the investor. And there are two different cases we want to highlight for you that just give you a sense of why this has gotten on the radar screen and why, as I'll comment in a moment, antitrust is probably among the 5 fingers of risk, if you want to put it that way, that anyone going into an investment ought to be thinking about from a diligence perspective. And so the first case on slide 16 here that we wanted to highlight for you is a civil case that was filed in the United States. This is a US class action that was filed on behalf of private plaintiffs, numerous direct purchasers of these canned tuna products, as well as classes of individuals who purchase those products. And what's interesting is less the subject matter of that case than one particular theory that the plaintiffs look to hold a PE investor liable in the case for, that is to keep them in the class action, subject them to discovery and potential trial on the liability issue. And the reason why it's interesting is because the particular PE company ultimately was found by the court not to have what has been discussed as sort of decisive influence or control over the local subsidiary that actually engaged in the alleged conduct, but instead was alleged in the complaint to have actually directly participated in the conspiracy. The theory being that they didn't actually effectuate the conspiracy by way of moving it forward. That is, they didn't sit down in smoke-filled rooms and engage in any necessarily bad conduct, but instead that they had knowledge and authority around the conduct that was occurring. And the theory was that in this case, the PE house, Lion Capital, participated in the conspiracy because it knew that its underlying portfolio company here, Bumblebee, must have been engaged in some form of cartel conduct because the market realities didn't suggest that the price of this particular product should have remained as high as it was, and that it was plausible that they would have continued to perpetrate or support Bumblebee's participation in that conspiracy because they stood to gain handsomely if the price of the product remained high, and therefore they could resell the asset at a higher price. So in essence, what the court was looking at and what the plaintiffs were alleging was that this particular PE house had invested in this company with the intention essentially to turn it around and resell it. And that if there was any sense, as alleged in the complaint, that the PE house should have known that the prices that were being charged by this particular entity were actually the result of a potential conspiracy, then they must have supported it, because it was in their interest to make sure that the profits of this particular entity didn't drop, because of course so too then would the resale value. So a quite tenuous theory. Most of us would obviously contest this, and it remains to be contested in court. But again, when we think about risks, which is what really this entire session is about, is sensitizing folks about the risks in the antitrust space. This one stands out as quite considerable. One, because private plaintiffs, particularly in the US and coming soon, I know they're already there in Europe and other places, are quite aggressive in looking for those entities that ultimately hold the deep pocketbooks. I would expect that where and if a plaintiff can allege any sort of plausible theory that a private equity company would have known that a portfolio company was involved in alleged conspiracy conduct on a going forward basis, we will see those entities named as defendants. And the theory will not be dissimilar to the one that exists here. That is, the motivations around the potential resale of the business, and focused on the fact that in the diligence process when they bought it, there should have been evidence of the fact that there was something amiss in terms of potential conspiratorial conduct. So again, a quite interesting case, I think a cautionary tale in terms of thinking about how you do your diligence going into a particular acquisition, and also in terms of the management. I think the one last note I'll just make on this case is, in terms of the evidence the court was looking at, there was also a sense that the PE company, in particular individuals in that PE company, were actively marketing the asset at times that were important around the potential activities, which taken alone are unremarkable in the context of the particular facts of that case, were I think ones that the court seized on and thought were helpful, at least in holding Lion Capital's feet to the fire in terms of having to answer to these particular issues. So I'll leave this particular example simply to say that, again, when you're thinking about diligence, when you're thinking about risk going into a particular acquisition, I think this particular case is just further evidence that antitrust should be on the short list of items that you ought to consider. And if we can maybe turn the slide. Not to pile on, but taking a look at the alternative theory, if we're looking at the Goldman Sachs case, which in this particular instance came down from the EU General Court the same year in 2018. It reflected on a 2014 decision by the EU Commission to hold Goldman Sachs liable, jointly and severally liable, for a cartel infringement by its subsidiary Prysmian, or its portfolio company Prysmian. And in that instance, what was important about that decision was the EU Commission's considerations about the decisive influence that they found that Goldman held over its investment here in Prysmian. And they looked at all of the issues that Jolly helpfully walked through, and I think in very particular detail, about their control over voting rights, their investment in the company, their overall shareholdings. What's interesting is they weren't 100% shareholder. They had actually started to lower their particular holdings in that investment, but they did hold on to the ability, for example, to control certain voting rights and the appointment of board members and the removal of board members. All of those things taken together, the EU Commission ultimately held demonstrated presumptive decisive influence, which then of course puts the burden on the other party to try to rebut that. Ultimately, the EU Commission found Goldman's explanation and defenses on that wanting, and more interestingly, so too to the EU General Court. And so unlike in the sense of the Lion Capital case, which was more about a theory of direct involvement and motivation, the Goldman Sachs case stands for the proposition that in terms of actually managing and controlling how you invest in a particular entity, that mere control alone can demonstrate potential risk in terms of being held liable. In this instance, the result of the case was that decisive influence, which the EU Commission again found presumptive, left left Goldman Sachs then vicariously liable for its percentage of the fine that ultimately was imposed on Prysmian. So in that instance, about 37 million euros. Quite substantial penalty ultimately for a investor in this particular entity when it was evident from the record that Goldman Sachs itself had no participation in the particular conduct, had no particular knowledge of that conduct, and was merely being punished as a result of its ownership and investment in that particular entity. So again, taking these two cases together, what are the risks here? The risks are we're seeing in the context of the Goldman Sachs case, regulators, so this is the EU Commission, getting increasingly aggressive in pursuing these kinds of theories. And in the US class action case, circumstances where private plaintiffs similarly are finding opportunities to go after deep pockets, in this sense, investors looking to drag them into private actions in order to pursue damages, money damages. I think at that, Paku, we're going to transition to maybe talking about not just the scary part of the actual risk, but how we might go ahead and prevent that. Did you want to have a few comments before we transition there?
No, John, absolutely. Thank you very much for that global perspective from you and Anisha. And I think on the law, and I think where we should now segue into is from Jolly, from the industry perspective as in-house counsel and legal director. As John said, what are the key ways and the key questions you would have for John and Anisha on ways that PE and VC companies can avoid some of these pitfalls?
So thank you, John, for that, and Anisha for that very helpful background on the jurisprudence and that is developing, which I think there is no debate that a private equity investor, if you're in a position of control, you should be in the position of a holding company, and what you are responsible for, and you should be held responsible for what you have done. But it goes the case, Goldman Sachs case, for example, that you mentioned, seems to go beyond that and seems to suggest that whether or not you were actually involved in anti-competitive activity, which was carried on by the portfolio company, and whether or not you were involved in the decision making or the actions that were taken, you could still be held liable, and effectively you're piercing the corporate veil to hold a holding company, which is a private equity investor, liable. That is, I do hope that will be challenged, and that there is slightly more, where liability is proportionate to the actions taken and not merely the ability to exercise control. So I do hope that is changed, that will appear on the side of jurisprudence. So I think from our perspective, the challenge, I guess, the risk is higher if you have investments in competing businesses, and so in that context, I guess the biggest question I have for John and Anisha at this point in time is, what are the key questions that one should be asking when doing due diligence and on an ongoing basis with portfolio companies, to make sure that you are not, you're not ignoring, or you're aware of risks and that you are addressing them appropriately. That's, I think, my key question in this context. And the second question that I have is, are there any preemptive steps that you can take to kind of mitigate this risk, and to mitigate the risk that you could be seen as responsible for the actions of your portfolio company? For example, would it help to frame a policy with regard to competitive activity? does it help to balance the board with independent directors? Are these steps, or are there other steps that one can take to mitigate the risk that as a private equity investor, controlling investor, or a minority investor, you could be held liable for the actions of your portfolio company?
So let me thank you for that, Jolly. Let me take a shot at least discussing first the diligence aspect of that, because that's where a lot of this starts, right? So you're looking at an investment and how do you consider those particular risks? I think lesson one is, for years, anybody who was looking to invest in a company would consider out of the box something like the anti-corruption aspects, right? So FCPA in the United States context, anti-corruption measures in other places was obviously a hot button issue. A lot of diligence would be done in or around that. I would say over the course of the last several years, at least what we've seen is that clients are increasingly including among the initial diligence and then deeper dive diligence that they do antitrust components to that. And frankly, the diligence between those areas is not markedly different. It's more about the lens that you look at it through than it is necessarily the questions that you ask. So what are the kinds of things that are important? And actually, if we want to flip to slide 19 here, we can show the audience a bit of these elements. But at a high level, what you're focused on in the first instance is asking questions around their antitrust compliance policy and understanding that and the training that they've provided to people within the organization to get a sense of the organization's understanding of those principles and frankly, their execution in monitoring whether or not their particular employees are anywhere close to the line on those issues. I think that's sort of job one. Job two then is asking the kinds of questions that you would again in other areas, but more antitrust specific around the kinds of complaints or other issues that the company may have had with regulators, regardless of where they're located over time, that whether styled as antitrust, look still like situations in which there is some restrictive element to their performance of their service or selling of their product in the market. So looking at those dynamics, asking those kinds of questions. And then finally, which becomes a little bit more of a review of the business practice than it is necessarily of potential complaints or compliance, is looking at their interactions with competitors. And in the antitrust context, you can tell a lot about a company's business and how much they rely on their interactions with competitors about how they're structured and what those activities look like. So asking questions about where they interact with competitors in terms of potential collaborations, that's obviously an area you want to ask more questions about, where they participate in trade associations, because the kinds of topics and things that they advance in those associations can be important. And then finally, how they rely and digest on potential competitive intelligence, right? Because a lot of these cases, as we see now, and frankly, the head of the Department of Justice's criminal program spoke about this just a day or so ago, information exchange, particularly in our world where we're so interconnected now, is driving a lot of the antitrust investigations and cases. Understanding how that information is exchanged in the industry and with the company that you're investing in is going to be key to understanding the risks. So I think from a diligence perspective, those are the issues that I would point out. And in particular, again, just going back to basics, ask the questions. I think we've had clients over time just realize that antitrust just has to be among those things where an initial questionnaire gets sent to the target and these kinds of evaluations need to be done upfront and then diligence throughout the process. Maybe with that, I'll ask Anisha if she wants to comment more specifically on the sort of management and ownership aspect that you asked.
Thanks, John. So I think John has covered most of the points, but I think I'll quickly add a couple of things. One is, which is an extension of the compliance point that he made. One is probably to have a strong and effective whistleblower policy, both at the sponsor level and at the company level, so that if there are any risks or any red flags, they can be quickly sort of addressed. I think thorough documentation of the entire decision-making process for your portfolio companies is something that as a sponsor, you should ensure, so that, that's another area where record keeping can help mitigate and sort of I would say, argue and contradict any allegations in the future. From a governance standpoint, it is obviously better that you have soft influence than active influence. So negative control is obviously more preferable over positive control, and similarly having an observer instead of having an active investor director would be more preferable to thwart allegations of active involvement in the portfolio company. But in addition to these, I think I will add a few things that can be taken as hygiene measures, and some of these sort of work very effectively. One is having a clean team mechanism. And what do we, for people who are not aware, a clean team is really having ethical walls, which consists of limited number of individuals that do not receive information relating to the competing portfolio. And this really ensures that the teams that are dealing with information relating to the respective portfolio are ring-fenced from each other, and its decisions are not influenced by the commercially sensitive information of the other company, to prevent any unintended coordination in market-facing activities. And this can be both inward and outward looking. The objective is obviously for the portfolio companies to operate autonomously and independent of each other. Second, which is increasingly becoming common, even in India, is to not have any common directors between competing entities, because these are routinely known to raise anti-competitive concerns and can potentially lead to coordination of business decisions. There is no active restriction in India on interlocking directorates, but it's prudent to sort of avoid this overlap to begin with, because the CCI has in fact adopted the spirit of this restriction in its decisional practice. Global jurisprudence on this is comparatively much more matured. So the US, Japan, South Korea, Indonesia, these are countries which statutorily actually prohibit a person from serving as a director in these two competing corporations, in sort of competing corporations. So I think these are additional practical tips that can be observed. And I hope I've been able to address this question. I would like to take this next slide to give you two quick examples to sort of elaborate that these are common measures that Commission in India is accepting. So I'm going to take one of these, and the other one, which is not on the slide, but it's a recent case, is another case that I would like to discuss. The first case is the case of IHH Healthcare's acquisition of Fortis. And as all the Indians would know, that these are active operators of hospitals in India and therefore active competitors. So what had happened was that the Commission noted that there was a joint venture that IHH had with Apollo Hospitals in the city of Kolkata. And the CCI had concerns that the JV between Apollo and IHH on one hand, and IHH's acquisition of Fortis, so the post-combination entity IHH plus Fortis, may provide a common platform for coordinated behavior. And in order to mitigate these concerns, IHH made certain voluntary commitments. And what were these commitments? They were exactly what we have just been discussing. The commitments were that IHH is going to make sure that the joint venture, the Apollo JV, and the IHH Fortis combined entity would operate as separate, independent, and competitive businesses. There will be no common directors on the board of the JV and IHH Fortis. The directors were asked to execute undertakings to state that no commercially sensitive information, including pricing data on day-to-day operations, would be disclosed to any director or board of the other entity. And there was largely a rule of information control that was imposed. The other two cases which are listed here also have similar operations, but because we're running short on time, I will not cover it. But what I would like to cover is a recent case involving a private equity investor in the pharma sector. And the decision of the Commission is in relation to acquisition of, again, minority shareholding in this pharma company, where the CCI analyzed concerns arising out of such minority shareholding in a situation where the private equity firm already holds certain shareholding in several of the target entities' competitors. The Commission noted that common interest of the acquirers or the private equity player that we are talking about in the pharma portfolio would give them the ability to sort of pursue anti-competitive goals. such as allocation of product, geographic market, customers, etc. And this potential could border between coordinated effects that we just discussed, and because of the common shareholding that would result. And in order to address these competition concerns, the private equity investor actually undertook to first remove their director on the board of the existing portfolio company with which there were massive overlaps, restrict the usage of information, the access to information that Jolly spoke about at length, relating to 3 other pharma portfolio companies that they had investments in. And they also undertook that they will not exercise certain affirmative voting rights and veto rights in relation to the same existing portfolio, which had demonstrated massive overlaps with the current target in relation to change in capital structure, merger and acquisition, and several of those standard rights. And what was also committed in addition is these commitments are going to continue so long as the investor has a nominee director on the target that is being acquired, or it exercised the veto rights that are not available to an ordinary shareholder under Companies Act. And these are very, very important observations and explains the mind of the CCI and how it is going to be treating, from a merger control perspective at least, new acquisitions or investments relating to entities where it already has a competing portfolio. Something to be mindful of even at the time of documentation, and this would go a long way in maybe speeding up approval timelines if these sort of issues are detected in a timely fashion and much more in advance. So Paku, over to you now.
Anisha, thank you very much. And John and Jolly, thank you very much for some of those ways to mitigate risk. We're a little over on time, but I think we'll end in the next couple of minutes, and I think we've got some questions. Let me very quickly ask each of our panelists, starting with Rajat, in 15 seconds or less for each of you, tell us the one thing you want our audience to take away from this webinar. Rajat? Why don't we move on to Jolly in the interest of time?
Sure. I think 15 seconds or less. Enhance due diligence on section 3 and 4 aspects. Look at industry, how they interact with their competitors in the course of due diligence. That's my key takeaway from here.
John?
Yeah, I would echo that. I would say, my 2 comments are think globally when you're talking about antitrust. Again, your risks are never limited just to the location of the entity. It's where the effects on the products would be sent. And then the other is to echo Jolly's comment, which is, as I said in my comments, antitrust should be on the 5 fingers of risk you consider when you're diligencing any investment going forward.
And Anisha, I'll give you the last word.
Yeah, I don't think I can say anything different, but really, I mean, even from an India perspective, these are real issues now. And I would encourage and urge all investors to, from a due diligence perspective, also look at antitrust issues, not just current ongoing antitrust litigations and taking warranties and indemnities on that, but also the potential risk that can arise. So that would be all.
Thank you, Anisha. And we have time for one question, and I think we're going to have to bring it to a close. We had several questions come in from the audience, but Anisha, there was one question about Schedule 5 of the Companies Act and fines and penalties.
Right. So Schedule 5 of the Companies Act, I think this has been picked up from the slide because I didn't on purpose cover it during my monologue. But Schedule 5 of the Companies Act for the uninitiated is a disqualification provision under the Indian Companies Act 2013, which says that a person is not going to be eligible for appointment as a managing director or a whole-time director or a manager if he has been sentenced to imprisonment or has been penalized or fined for an amount exceeding 1,000 rupees under one of the several acts which are listed there, and one of the acts is Competition Act. So this was really in the context of what is the risk for individual directors, and this is one of the risks that we do highlight is the power under Companies Act. If you're held liable under Competition Act, and Competition Act, as you would know, has very high penalties and fines. It's a civil statute in India, so it's all civil monetary fines, not imprisonment. But if you are found to be if you are held liable under the Competition Act and found to be in contravention, then you also risk disqualification under the Companies Act, the Schedule 5.
All right, thank you, Anish. And unfortunately, that's our time limit on the questions. We've listed the email addresses of all the panelists, so please feel free to email any of us or at the keythonco.com email at the top. Just let us know and we'll try to respond to you. So ladies and gentlemen, thank you so much for joining us today. I think on behalf of John and Simpson Thatcher and the IVCA, and of course Anish and myself from Ketan & Co. as the co-host for this, we very much appreciate the time that you've taken. And John, Jolly, Anisha, and Rajat, thank you so much for the insights on this. I think the one takeaway that I have is competition law is something that is highly relevant. There are risks, but as you have both, all of you have pointed out, there are ways to mitigate that. So ladies and gentlemen, thanks again so much. We'll be sending you the slides and additional information shortly. That's all from us. Please take care and be safe.
Thank you.